Hello, everyone, and welcome again to Aaron Reads from Remedies. That intro was provided by my lovely musical brother Owen. Check him out wherever you can find him. He is the best. So today we are covering damages where value cannot be measured in dollars. We only have one case today. It's Debus versus Grand Union Stores, a Vermont case from 1993 that is gone to the second district in 93 for the appellate court in the second district. So here we go. Justice Johnson writing the opinion. Plaintiff was injured while shopping at defendant's store on August 23rd, 1985, when a pallet of boxes, piled high and imbalanced, toppled over and fell upon her. Whoa. The boxes, containing cans of pet food, tumbled off the pallet and onto plaintiff when a store clerk attempted to move the overloaded pallet. Plaintiff suffered injuries resulting in a 20% permanent disability. The jury awarded plaintiff damages of $346,276.23. During closing argument, plaintiff suggested that the jury think about plaintiff's injury in terms of daily pain and suffering, and then determine what amount of damages would be appropriate compensation for each day of suffering. An average daily figure was suggested to the jury, which it could then multiply by the number of days plaintiff would live, counting from the day of the accident until the end of her life expectancy, some 35 years. The jury was told to consider the figure only if it found that the calculations useful in quantifying plaintiff's damages. Defendant contends that such a per diem argument are unduly prejudicial and should have been disallowed by the trial court. Defendant further contends that if per diem arguments are permissible, the court should have given cautionary instructions. A per diem argument is a tool of persuasion used by counsel to suggest the jury to the jury how it can quantify damages based upon the evidence of pain and suffering presented. Other jurisdictions are divided as to how to allow such arguments. The principal reason advanced against per diem arguments is that a jury's verdict may be based upon the evidence before it, and a per diem figure, which is not in evidence, allows a jury to calculate damages based solely upon the argument of counsel. Further, courts have reasoned that a per diem argument unfairly assumes that pain is consistent, uniform, and continuous, and that the pain will prevail for the rest of the plaintiff's life. Therefore, it creates an illusion of certainty in the disability that is more likely to be subject to a great variation. Finally, some courts conclude that the jury will be too easily misled by the plaintiff's argument. On the other hand, jurisdictions that have allowed per diem arguments counter that sufficient safeguards exist in the adversarial system to overcome the objections to its use. They point out that plaintiff's hypothesis on damages, even if presented on a per diem basis, must be reasonable or suffer serious and possibly fatal attack by the opposing counsel. Further, the notion that pain is constant and uniform may be easily rebutted by reference to evidence or to the jury's own experience. More importantly, they note that juries are entitled to draw inferences from the evidence before them, and that the extent of damages attributable to pain and suffering is a permissible form of inference for the jury. After review of the arguments and authorities, we are persuaded that there is nothing inherently improper or prejudicial about a per diem argument if they are made under the ordinary supervision and control of the trial court. In cases where claims for pain and suffering are made, juries are forced to equate pain with damages. The jury can benefit by guidance offered by counsel in closing arguments as to how they can construct that equation. We permit counsel reasonable latitude in this phase of the trial to summarize the evidence, to persuade the jury to accept or reject the plaintiff's claim, and to award a specific lump sum of damages. If a lump sum is to be suggested to the jury, footnote, counsel's request that jury award a lump sum amount is not error per se, although the lump sum may be consistent with counsel's hope that with the reliability of the evidence, a lump sum, like per diem damages, argument is not reversible error unless it shouldn't be prejudicial. So basically, unless the counsel argues that a lump sum payment argues that in such a way that it constitutes clear error in the court below, the appellate court is not going to reverse it. So basically, unless they really overdid it, that's not clear error. They're not going to reverse it. Good to go for it. Okay. It cannot be impermissible to explain how a lump sum was determined, nor can we agree with the defendant that per diem arguments must be accompanied by specific instructions. Juries are routinely instructed that arguments and suggestions by counsel are not evidence, whether or not a party makes a per diem argument. It may well be that other instructions may be required when per diem arguments are used, but we leave that to the trial courts. The fashioning of instructions and the controls appropriate to the cases before each trial court. Our, our holding should not be taken to grant the plaintiff carte blanche to depart from any reasonable view of the evidence. Rather, it reflects our confidence that the defendant's opportunity to refute the plaintiff's closing argument will ensure that an absurd hypothesis will be rejected. Even if it's not, and the verdict is excessive, the trial court has adequate mechanisms such as remitter to deal with it. Remitter allows the judge, in the absence of the jury, to dial down the amounts awarded to make it more in tune with the amounts the appellate court might reduce to, and therefore make the case more appeal-proof from the trial court judge's perspective. The question remains as to whether the per diem argument in the present case was improper. In closing arguments, the plaintiff's counsel told the jury the per diem figure was only a suggestion for its consideration, and that determining a fair amount would be entirely up to the jury. He did not argue the plaintiff's pain was constant, uniform, and easy to quantify on a daily basis. In fact, the counsel told the jury that the pain fluctuates and that he was only suggesting an average figure for their consideration, and told them to, quote, disregard it if it is not helpful, end quote. Defendant had the full opportunity to rebut the per diem argument and did so. We cannot conclude that this argument invaded the provinces of the jury. The case was submitted to the jury with appropriate instructions. The trial court cautioned the jury that the arguments of the attorneys and any statements which they made in their arguments or in their summation is not evidence and will not be considered by you as evidence, and that, quote, it is recollection of the witness's testimony and not the attorney's statements which will control your reaching your decision, end quote. The court made it clear to the jury that the final determination of damages was not to be made on the evidence alone and not on persuasive arguments or by any particular formulas. That the jury was able to make this distinction between presented evidence and suggested formulae is demonstrated by their arriving at the total damage award of $166,194, below the figure suggested by plaintiff's counsel, which figured counsel calculated in part by using the per diem formula. This was no error, affirmed. Apparently, Chief Justice Allen, not very happy. He dissents. He dissents, and he says the majority reasons that if a lump sum award may be suggested to a jury, it cannot be impermissible to explain how the lump sum was determined. The difficulty with this rationale, however, is that until today it has been improper in Vermont to mention to the jury the lump sum being sought. The amount which the plaintiff hopes to recover is not evidence, proof of the amount due, or standard for estimating the damages. He's got a point on that. It is unnecessary here to set forth the various arguments in favor or against the per diem arguments, as they have been thoroughly and exhaustively discussed in the opinion from virtually every other jurisdiction over the past 30 years. I believe the best answer is to permit counsel to argue to the trier of fact the appropriateness of employing a time unit calculation technique for fixing damages for pain and suffering, but to prohibit any suggestions by counsel of such specific monetary amounts either on a lump sum or on a time unit basis. This approach was suggested by King versus Railway Express Agency, North Dakota Supreme Court, 1961, and was also adopted by a rule in the New Jersey Rules 1-7 Tac 1 Bravo in the New Jersey Rules of Court. The ultimate objective here should be to aid the jury in determining what sum of money will reasonably compensate the plaintiff for pain and suffering endured. The attainment of this goal is not enhanced by counsel arguing the dollar amounts that they desire to have a jury return. The fair and practical solution is to permit the jury to hear about the methodology and to apply the dollar amounts from the evidence rather than the sum suggested in the argument. I further disagree with the majority on its reluctance to require a specific calculatory instruction, because the general language offered that the arguments of the attorneys and any statements they made in their arguments or in their summation are not evidence and will not be considered by you as evidence, end quote. The instruction approved by the majority may be adequate to deal with remarks of the attorney that are plainly argumentative. However, the difficulty is that remarks regarding numbers or dollar amounts may not appear to be argumentative, but rather appear to be evidence itself. Hence, the instruction not to consider arguments as evidence does not entirely cure this problem. To see where it's going. The majority relies upon the proposition that, in closing argument, the plaintiff's counsel told the jury that the per diem figure was only a suggestion for its consideration, and that determining a fair amount would be entirely upon the jury. End quote. The majority is overly generous. Counsel's remarks are at best ambiguous and come to the beginning of a lengthy and detailed mathematical presentation. That presentation stated as part and follows. Get ready for a mathematical presentation. Woof. What award, quote, what award would it take to tell Grand Union what accountability means and what that is worth to the people of Bennington County and what they think a human life and human suffering is worth? Now, let's just take one element. We have talked about pain and suffering. What would be fair compensation for pain and suffering? It's entirely up to you. I have suggested, if you think about what it is like for Suzanne to go through one day with the pain that she has, and think about what would be fair compensation for that one day, what would you think it would be? Would it be $100 to go through that day? Would it be $75? Would it be $50? Would it be $40? Ladies and gentlemen, we want to be scrupulously fair about our request to you. So I'm going to suggest to you that you award Suzanne only $30 a day for the loss of those three elements: pain, suffering, mental anguish, and the loss of the enjoyment of her life. That is $10 for each day, a day for each one, for each of those three elements, right? I put it to you for your consideration the following, though. You would do it this way if it were 365 days a year. I'm just going to put here a pain and suffering, mental anguish, loss of enjoyment of life. Now, there are 365 days in a year and 35 years total that she's expected to live and be compensated for. So if you multiply 35 by 365, those are 12,775 days. And if you simply multiply that figure by $30 a day, I suggested it comes out to $383,250. $383,250. Now, another way of thinking about this is if you divide 35 years into this figure of 383,250, it comes out to slightly under $11,000 a year. Maybe that would be a help to you to think of $11,000 a year to live the way she lives, to live the way she is being forced to lose what she has lost. Perhaps it will help you. I don't know. The caveats in this argument are nearly invisible. An additional statement in rebuttal is no better. The residue is a set of specific numbers that are, by the majority's holding, proper, but which is less deserve a specific cautionary instruction. Yet the majority would substitute counsel's at best ambiguous message for a clear instruction from the bench about the use of numbers. I would not do this, and I dissent, says Justice. Allen, the Chief Justice, dissenting. Well, there we are, kids. We have a sick day. It's a good day. Hope you like the new intro. Good speed, Godspeed, good bless, God bless. I will see you on the flip side.